Hung Nguyen, civil number 16-00659, JMS-KSC. We have Commissioner Levinson's statement regarding vote to deny.
We don't seem, the commission doesn't seem to have, by way of statute or rule or otherwise, any mechanism for dissenting commissioners from a decision of the majority of the commission regarding requests for representation at city-county expense to put their positions on the record. In fact, the findings of fact, conclusions of law, decision, and order in the Nguyen matter was circulated at the beginning of the meeting for signature, and I was told that I was expected to sign it, notwithstanding that I disagree with all of that. And where I come from, dissenters don't sign majority orders or opinions. They set out their position separately. And so I had earlier requested that Chair Sword give me an opportunity by way of putting an item on the agenda to put my position on the record with respect to this matter, and that's what I propose to do now.
Did it go around today? I'm sorry. Did the thing go around today to sign?
Yes.
Did I sign?
You signed it before because we thought you were going to be here yesterday. The
Oh.
meeting was scheduled for yesterday.
Okay.
As a global matter, having thought about the Nguyen request at length, I am convinced that, among other things, the findings of fact, conclusions of law, decision, and order was made upon unlawful procedure in violation of Section 91-14 G3 of the Hawaii Administrative Procedure Act, and potentially even worse, the whole proceeding was in violation of constitutional or statutory provisions within the meaning of Section 91-14G1, both of which would constitute grounds for an appeal of the Commission's decision to the Circuit Court and ultimately to the United States Supreme Court, the Hawaii Supreme Court. I think there is a fundamental misunderstanding under which the Commission has been operating for years, essentially by virtue of advice given to it by the Office of the Corporation Counsel, that for purposes of 52D-8 and 9 contested case hearings, there is an attorney-client relationship between the Commission and the Office of the Corporation Counsel. There isn't. HRS Section 52-9, which along with Section 8 creates our jurisdiction to pass on requests for legal representation by police officers, merely requires that the Police Commission consult Corp Counsel, who may make a recommendation to the commission with respect to the request for representation if corporation counsel so desires. That doesn't establish an attorney-client relationship at all. It simply requires that before the commission makes a decision, it asks corp counsel for a position period. I'm looking at section 5-203 of the city charter, which describes the powers, duties, and functions of the corporation counsel. It says, among other things, that the corporation counsel shall serve as the chief legal advisor and legal representative, among other things, of all agencies and employees. Well, we're an agency of the city and county of Honolulu, and for some purposes, corp counsel may be our legal representative. But the requesting police officers are employees of the city and county of Honolulu, and if you read the provision of the city charter literally, there is therefore an attorney-client relationship, according to the department, between the requesting police officer and corp counsel, and that's obviously not true. It also can't be the case that with respect to these contested case hearings resulting from requests for legal representation, that corp counsel is acting as our attorney, because corp counsel is one of the adversary parties appearing before us. And so you can't have, the adjudicating body can't have its own attorney advocating on behalf of the adjudicating body adverse to the interests of the requesting party before it. That would be, to me, a clear violation of the due process rights of the requesting officer. Under the guise of an alleged attorney-client relationship between corp counsel and the commission in the context of 52D 8 and 9 contested case hearings, corp counsel has claimed an attorney-client privilege with respect to the memoranda that it submits to the commission in advance of the contested case hearing, setting out its analysis, which up to this point, in my view, has been as wrong as it could possibly be, recommending denial of the police officer's request for legal representation. That is an improper claim of attorney-client privilege because there is no attorney-client relationship in that context between corp counsel and the commission, and therefore what we get is a situation in which corp counsel, which is an adversary party to the proceeding, is feeding the commission legal analysis which is not available to the requesting officer, who has the burden of persuasion and proof with respect to entitlement to legal representation. On its face, it seems to me that that constitutes unlawful procedure for purposes of 9114G3, and to the extent that the requesting officer's due process rights are compromised by virtue of that long-standing practice, I think we have unconstitutional procedure that violates the officer's right to due process of law, and arguably violates the letter of section 52D9, which simply requires that the commission consult with corp counsel before making up its own mind independently, and affords corp counsel the prerogative of refusing to weigh in one way or the other. With respect to the particular findings of fact and conclusions of law, findings of fact 3 through 5 find that there was no evidence that the allegations in the complaint concerning Nguyen occurred while Nguyen was on duty with the Honolulu Police Department. There was no evidence that the allegations of the complaint concerning Nguyen occurred as a result of his following a superior officer's orders. There was no evidence that Nguyen handled evidence, wrote reports, performed investigations, or performed any other police duties. That one is particularly important. And then there's a finding that the commission makes no findings of fact regarding the merits of the complaint. Well, findings of fact 3 through 5 do make findings regarding the merits of the complaint. Those findings purport to pass judgment on whether particular allegations in the complaint are true or false. That goes to the merits of the complaint, and that is not within our prerogative to do. What is before us is whether the complaint alleges conduct constituting acts done in the performance of duty, of an officer's duty as a police officer. And so finding of fact 6 is clearly erroneous because the commission is making findings of fact regarding the merits of the complaint, and findings 3 through 5 are improper because the commission is not permitted to pass judgment on the truth or falsity of the allegations of the complaint. That violates section 91-14 and constitutes grounds for an appeal to the circuit court and ultimately the state Supreme Court. Conclusion of law number 1 states in relevant part that Nguyen's alleged actions were not taken in the performance of his official duty as a police officer so as to entitle him to legal representation provided by the city and county. And this is consistent with the analysis that Corp Counsel provided us in its memorandum
Just real quick, please, Steve. You're saying Nguyen was not in the scope and course of his duty?
That's what the commission ruled.
We ruled that he was not.
In the contested case proceeding.
Okay.
That's consistent with the analysis of Corp Counsel in its secret memorandum to us dated April 13, 2017, which should not be secret, considering that there is no attorney-client privilege in this relationship, in this context, between Corp Counsel and the commission. I would like to make the April 13 memorandum from Deputy Corp Counsel Leslie Chin to the commission with respect to the Nguyen matter part of the record. I refer specifically to her statement at page 6 of the memorandum that Nguyen's alleged mishandling of evidence and falsifying reports by Nguyen was not within the course and scope of Nguyen's duties as a police officer. That's the conduct that is alleged in paragraph 45 of the Puana versus Kealoha complaint. in connection with which Officer Nguyen is a party. Inexplicably, 8 days earlier, the same Deputy Corp Counsel, Leslie Chin, submitted a memorandum ostensibly subject to the attorney-client privilege and therefore confidential with respect to the claim for legal representation by Drew Akagi, in which the same allegations were advanced by the plaintiff against Officer Akagi as were addressed in the complaint against Officer Nguyen, with one additional allegation leveled against Officer Nguyen. But with respect to the allegations against Officer Akagi that Deputy Corp Counsel Chin decided with respect to Nguyen were not conducted within in the performance of his duty as a police officer. As to Officer Akagi, in her April 5 memo, she wrote, quote, "The conduct alleged in the complaint to have been taken by Akagi was done in the course and scope of his employment as a police officer. Accordingly, it is the recommendation of that Akagi's request for legal counsel be granted." So I think we also have a degree of arbitrariness and capriciousness here. It's essentially a crapshoot or a roll of the dice as to whether Corp Counsel will view the identical allegations as alleging acts done in the performance of duty or not, depending on who the officer is and whatever presumably the Deputy Corp Counsel had for breakfast. So I think there's a lot that's appealable to the circuit court, and that would result in a reversal of the circuit court of the commission's decision. And I am convinced that if and when the matter went to the Hawaii Supreme Court, that we would be the recipient of some harsh words, and I think the Office of Corp Counsel would as well. And for those reasons, I voted to grant Officer Nguyen's request for legal representation. I believe that the conduct alleged in the complaint, and that's all we should legitimately be looking at, does allege acts done in the performance of duty as a police officer, as Corp Counsel found that the allegations against Officer Akagi were.
May I ask a question?
Oh, and I'd also ask that the April 5 memo written by Deputy Corp Counsel Leslie Chin regarding the Akagi request, in which he recommends granting it, be made part of the record in this proceeding as well.
You have to attach it to the minutes. That's how you make it.
Then I'd request that both be attached to the minutes.
So let me see if I'm tracking you correctly, if I'm understanding. What you're saying is we're supposed to be an independent body that adjudicates, decides whether police officers get a lawyer paid for by the city and county of Honolulu. That's the first step, right?
Yes.
And then Corporation Counsel comes before us in an advocate position, and they represent the city and county of Honolulu, telling us essentially, you shouldn't pay for his lawyer. That's the second step, right?
Yes.
And then the third step is, in the same breath then, Corporation Counsel turns around and acts as our advisors, our law clerks, and tells us, you should deny this officer the counsel paid for by the city and county of Honolulu. And so,
Yes,
did I get that
and
right?
4 advises us that we can't tell anybody what Corp Counsel has recommended to us because it's privileged.
So we're being advised your allegation is you're being advised by biased lawyers who are trying to keep this all secret.
Yes.
Okay, my only concern is, and I hear you on every single point, is.
Well, biased. Lawyers with a vested interest in a position that represents the interests of their client, which in this case is the city and county of Honolulu.
Would this be, I agree with you on the confidentiality. Would this be a solvable problem if there was a firewall erected within Corp Counsel whereby the lawyers who are advocating and saying, don't pay for his counsel, and the lawyers who are advising us, there's a firewall, and those two lawyers could never speak with one another, or could that be a solution?
I think the answer, my answer is no. That could not be a solution, and here's why. Section 52D9 is the statute that requires us to ask for a consult with Corp Counsel. That does not establish an attorney-client relationship. It simply asks us or requires us to request a consult with the city's lawyers. And if Corp Counsel chooses to weigh in on the matter, it's doing so in its capacity as the city's lawyers.
But it would be totally improper. I mean, why would a statute require us to consult with the lawyers for one side and not the lawyers for the other side? Maybe the statute is actually contemplating that we consult with Corp Counsel because historically this has not been a body full of lawyers, and they might need to talk to a lawyer.
Well, I think one would have to speculate as to what the answer to your question is, because I doubt that the legislative history underlying the relevant sections of 52D really speak to the matter. But if I had to guess, my guess would be that in 1941, the legislature thought it would be a good idea for the commissions to find out up front if the county's lawyers had any objection to granting the requesting officer's request.
So then it's all done with a wink and a nod. Is that what you're saying?
No. I don't think any of that establishes an attorney-client relationship between Corp Counsel and the commission. The Corp Counsel does have an attorney-client relationship with us as to some matters, but not these contested case proceedings.
Okay. So where do we go from here?
I wasn't
question.
asking that there be
No,
any
yeah.
further deliberation.
Yeah, he just wanted to be
I
on the
want
record.
all of that on the record, and I very much hope that Officer Nguyen appeals this, because I want it to go to the Supreme Court.
Will he know, Steve, what's going on here? I mean, will he at least have a second
I
chance?
bet he'll
Yeah,
know tomorrow.
Yeah, it'll be on the record for that.
I mean-
Yeah. Okay, anything further there, Commissioner Levinson?
No.
No?
Thank
Okay.
you.
Then
No, thank you.
for. All right, announcements for our next meeting.